Hi, everybody. It's Danae here. I am here to talk about employment tribunal. If you've got an issue going on with your employer and you want to know what is legal, what's not legal, all that kind of stuff, that is what I am here to do. So if you have a question about employment tribunal, hey, Alina, great to see you here. So yeah, if you have a question about employment tribunal, about grievances, disciplinaries, things like that with your employer here in the UK, then I am here for the next half hour or so to answer your questions. So feel free to just type your question in the chat and I will do my best to help. And if you don't know who I am, my name is Danae and I own a company that helps people represent themselves in employment tribunal. The general idea is that nobody can afford a full fat law firm. And so a lot of people decide to do it themselves, but they don't know what to do and they don't have a lot of support tools or things available to them. And so that's what we're setting out to fix. We have built an entire platform. Most of it is free for people to represent themselves in tribunal. And then we have coaching services on top. We have templates and documents that you can use on top. And I do a lot of lives like this just to answer questions, just to help people understand what your options are. Now, if you are in the tribunal, Alina says, my employer is willing to negotiate a settlement via ACAS in the case that I leave the workplace forever. That's a great outcome, Alina, and very common to go through ACAS early conciliation and actually negotiate a proper settlement. How is the settlement offer looking for you? Have you asked for what you want? Are they making an offer that feels like the right offer for you? Happy to talk through kind of how to think about settlement negotiations, how to think about how much to ask for, price, all that kind of stuff. And while Alina is typing, I'm just going to put a link in. We actually have a free support group that is happening this Thursday night, tomorrow night. So if any of you would like to come, if you are going through employment tribunal, or if you're thinking about going through employment tribunal, this free support group is so lovely. We are all it's just such a lovely group of people, and we answer questions with each other, you swap tips with each other, and generally just try and hold each other up because sometimes this stuff can be super stressful. So I've just put the link to the free support group in the chat just now. So Alina says, I raised a grievance about disability harassment, discrimination, and failure to make reasonable adjustments. Huge well done. Alina, are you aware of victimization as well? So if you raise a grievance about any type of discrimination with your employer, and then if your employer treats you badly as a result of having raised that grievance, that could also be illegal, and that's called victimization. Okay, they asked me to make an offer. They won't allow me to transfer to a different setting, so it's either going back to face my bullies or leave with a settlement. Okay. And are you currently trying to price what you think that offer would be? Is that the kind of stage that you're at the moment? Has ACAS given you any guidance on that? How are you going about deciding how much to ask for? I can talk you through kind of the common approach that we recommend people think about. In the meantime, I see I have a few other people here. Please feel free to say hello in the chat. If you're just lurking, that's wonderful too. It's wonderful to see you here. But yeah, I'm very happy to answer questions if that's useful. So Alina says, ACAS won't advise, and I have no idea. That makes sense, Alina. So what I would suggest that you think about is, it sounds like you've got a pretty good idea of the potential claims that you would make if you had to go to tribunal. And that's really the key. That is the number one thing to focus on, is properly identifying your legal claims. Because then you can actually work out how much to ask for based on those claims. Because if you went to tribunal and won your tribunal case, so let's say that you won for all three claims that you've described there: disability, harassment, discrimination, and a failure of reasonable adjustments. In that case, the tribunal will have an approach that they take to those particular types of claim. And they'll work out how much they would award you. And so typically when people are negotiating a settlement, they start with that number and then they work backwards from there. So they say, look, if I went to tribunal and won, then my award might be in the range of this, and you would have your legal fees on top of that. So why don't we just call it at this number? A couple of solicitors told me that I had no chance to win as it's under 2 years of employment, the harassment is not that bad, etc. So being under 2 years of employment has nothing to do with disability, discrimination, and a failure to make reasonable adjustments. All of those are related to the Equality Act, and the Equality Act applies from the hiring process onwards, but certainly from day one of your employment. The things that kick in after 2 years are unfair dismissal and constructive dismissal and redundancy pay. But automatic unfair dismissal, that starts from day one. And automatic unfair dismissal is is related to discrimination or whistleblowing, and discrimination in general, harassment, a failure to make reasonable adjustments. I thought I knew but yeah, it sounds to me like you know the Equality Act better than these solicitors as well, Alina. So yeah, just to reinforce, you're absolutely right. The 2 years has nothing to do with this. So let's just see. I'm just looking at Quietly Soulful. Thanks for your question. I will come back to you in just a second. Right, so you've worked there from the 31st of January until May when you went on sick leave. So Alina, when you think about how much to ask for a disability claim, for a discrimination-related claim, there's a few things to think about. One is, if you win on one type of discrimination, your award will just be a discrimination award typically. If you win on 3 types of discrimination, you don't get the same award 3 times, if that makes sense. So you could probably just bundle together everything into a general kind of discrimination award. And discrimination awards will include past losses, future losses, and injury to feelings. So past losses is, for example, if you were dismissed and they didn't pay your notice, or they haven't been paying you for a while, or they didn't pay you your holidays, or anything like that. And the past is basically from the point where you write the offer. So everything that you have incurred as an expense, or they haven't paid you in the past. And that also includes things like holiday pay, benefits. And if you got another job, but it pays less than the job that you had, then you can put the difference as a past loss. Then there's future losses. So has it impacted your ability to get another job? How long will it take you to get another job of the same value? It might take you another 3 months to get another job or something like that. That's a potential future loss. And then injury to feelings is the big one for discrimination cases. And this is an award specific for discrimination that literally compensates you for the injury that this caused to your feelings. And it goes in 3 brackets. The first bracket is for one-off situations or stuff that made you feel hurt, humiliated, upset, but it didn't ruin your life or ruin your career. The third band is for stuff that did feel like it ruined your life and ruined your career. And the middle band is for everything else. You've been physically sick. Yeah, that feels like, that's the kind of information that you would take to, that you would put into a vento band, or put into an injury to feelings document to justify the middle band. Alina, it sounds to me like you're pretty clued up on everything. Well done. I've got a few suggestions for you. One is we actually have what's called a merits assessment service. And we could help you price how much to ask for using that merits assessment service. Let me just get the link for you. And that's when one of our coaches will have a look at your claim and look at the details that you have. And then you can just say in there, I'm looking for help to exactly understand how much to settle for. And they'll give you an idea of the strength of your case and also how much they think that you should be thinking about asking for. Let me just get the link for you. So if you would like to do that, then there's the link for that. The other thing is, if you do want to do it on your own, which is totally understandable, we're going to be doing a injury to feelings webinar It'll probably be in the next week or two, and that will be specifically about how to price injury to feelings claims. So we haven't released that yet, but if you are on our mailing list already, if you're not, just sign up for a newsletter or something on our website. We'll send you the information about that. Right, I'm going to quickly move over to Quietly Soulful while you're typing back anything else. So Quietly Soulful says, I've sent my ET1 and on the 20th May. I did call in to June. Oh, good. I'm glad you're coming tomorrow night, Alina. That's fantastic. I called in to find out when I would hear a response. They said 20 days. I may hear something. As of yet, it's still nothing. Okay, so 20th May, 20th June, 20th. I have phoned the office subsequently and the phone just hangs up. I sent an email. How would I be told that the tribunal has accepted my case? Quietly Soulful, did you get a confirmation letter from the tribunal to say that they had received the case? So are you waiting for that, or are you waiting for the employer to send their ET3 response in? Oh, thank you, Alina. That's wonderful. I also have ADHD, so it's neurodivergence unite. So yes, Quietly Soulful. Let me just double check I've understood. Have you not received any confirmation yet that your claim has been met or seen by the tribunal at all? Yeah, I thought I remembered your name as well. I'm going to give you, can I? Oh no, I can't do a love heart. That's a shame. I wanted to do a love heart on you. Right. Whilst I'm waiting for Quietly Soulful to reply back, let's hear from Linda. Thank you, Linda. I am physically disabled, but my employer says that my complaint about not making reasonable adjustments were about mental health, which they do not recognize. Am I still covered as a disabled person? Now, Linda, first of all, I'm so sorry that you're dealing with this. This sounds so stressful. So can I just get a little bit more information from you? So you asked for a reasonable adjustment because of a physical disability, and then they said, no, what you're asking for is more of a mental health disability, and we don't recognize that, therefore we're not going to make this adjustment. If that's the right understanding, I'll just answer some of this now. One is mental health disabilities are still disabilities. So for example, Linda, if you have a physical disability, but you also have been diagnosed or medicated for depression or anxiety, for example, then that is also a disability. So yeah, that's number one. And number two, they don't get to decide whether or not you have a disability. Occupational health can advise on it. Your doctor gets a say in it, and ultimately the tribunal can decide if you have a disability, but your employer doesn't get to make that decision, especially not without an occupational health review. So has occupational health gotten involved is my next question. Back to Quietly Soulful. I received an email when I did it. I have a submission number. I don't know if the tribunal has accepted the claim. Quietly Soulful, which area are you in? Which tribunal is it across the country? Because I've heard of this a few times recently. I think there's a big delay at the moment. And what I'll do is, I don't know if you're coming to our support group this evening or tomorrow evening, Southeast London. Now, I do remember it was London last time I heard about this. So what I'm going to do is tomorrow evening, I'm going to ask if other people are seeing these same kinds of delays. I do remember the last time we had a support group that people were saying that the tribunal was advising them it could be up to a month or so before they're kind of properly processing their claims. So unfortunately, I think this might be normal, especially in London, as I think that's where the problems were happening. And I know you phoned them and they're just hanging up on you, which is... You would be sent an email and a letter that would tell you that your claim has been accepted. And most claims are accepted. Usually the only reason that a claim isn't accepted is if, for example, it doesn't have an ACAS certificate number or something like that. So I think you could probably assume that in most cases your claim will be accepted, But then obviously you're waiting to find out, has my employer been notified about this? Do I have a preliminary hearing scheduled? All that kind of stuff. Yeah, are you planning to come to the tribunal support group tomorrow night? Are you aware of it? And if so, we can both talk about that. We could talk about that at the support group tomorrow night and just see if anybody else has any advice as they're, phoning up the tribunals regularly as well. And I could ask who else. Oh, good. Okay, so in that case, I'm just going to make a note to my team and say at the support group tomorrow night, don't let me forget to ask if anyone else is dealing with the South East London Tribunal, as we have a user, Quietly Soulful, who has been waiting for an acceptance of their ET1 since 20th May. Ask what is normal. Okay, so we'll I'll ask the group tomorrow night, and we'll see if we can get some other people talking about that. Okay, so Alina, my employer put some veiled threats after hinting I was in the wrong for not disclosing my ADHD and APD before employment. You're very welcome, Quietly Soulful. Looking forward to seeing you tomorrow night. Police and Ofsted. You don't have to disclose a disability. They have no right to know whether or not you have a disability during the hiring process. You have protections if you do decide to disclose them, but they can't force you to disclose a disability, to my knowledge. And the only time that I could think that might be an issue is if you are in some kind of role where they could make some kind of an argument that it would be like a safeguarding thing or like a safety related issue, that they would need to, put other kind of like steps into place to make sure. Is that classed as the last act of discrimination, harassment, or victimization? It's a good question, Alina. I would want one of our coaches to have a look at that and give you a proper answer. But I think as part of an overall, if you're pulling together like an overall pattern of behavior, I don't know which one of those boxes that particular thing might fit under without knowing the rest of the context, but it certainly feels like it would be contributing to that overall pattern of behavior, of discriminatory behavior. Hi, Andre. So yeah. Yeah. Okay. Yeah, in that particular case, though, I do think a merits assessment would be better because I'd like one of our coaches to have a look at the specifics of what you're talking about. Okay, so Linda, occupational health oh my God, I work in a nursery and sorry, Linda, I'll come back to you. She was trying to twist things to make it sound like I was unable to care for children. Okay, that sounds to me like direct discrimination. Like, saying basically because you have ADHD or ASD or both means that you can't care for children. Sorry, I'm just speechless because that's so fucked up. Sorry. Yeah, that sounds to me like either harassment or direct discrimination on the basis of the protected characteristic of your disability. Saying that you are not capable of caring for children because of your disability is straight up discriminatory. And implying it or saying it is really shitty. So I'm really sorry. Right. Linda's saying occupational health were involved. I have asked for the reports from the 17 counseling sessions for the tribunal in August. Okay, so your tribunal date is in August. So has occupational health employer only giving bare denial and mere assertions in their defense? Okay, Linda, a few questions for you. It sounds like you are in the tribunal process. Is your final hearing in August or is your preliminary hearing in August? And if it is a preliminary hearing, is it a preliminary hearing to determine whether or not you had the disability? That's called a substantive preliminary hearing if it's a hearing scheduled to determine whether or not you had a disability, for example. Could Could you please add this question for tomorrow? Yes, I will. Also, question around okay, so Linda, let me know about that. Andre, if you have any questions, feel free to fire them in. Like, I'm just making a note about this. Can they use my anxiety and depression against me? Again, anxiety and depression are disabilities. Disabilities need to be accommodated. They need to have reasonable adjustments put into place. But to imply that someone with anxiety and depression can't do their job is different. Now, there might be some safeguarding issues or something like that that have to be considered when an employee has anxiety and disabilities. But they would need to be very careful about making sure that they weren't disproportionately checking those safeguarding things with you. Because the fact that you have ADHD, ASD, anxiety, or depression, or any of those together, does not disqualify you from doing a great job in your job. Okay, I've just made a note about that. Oh yeah, so I mean, you've worked in childcare for 14 years, so they're literally just discriminating against you. Andre, you don't have to, I hope I'm pronouncing your name correctly, by the way. You don't have to ask any specific question if you don't want to. You're more than welcome to just hang out and listen. I just want to make sure that if there is something that you want to know about, I'm happy to help. If you're in a particular situation and you want to know more or something along those lines. But you are also more than welcome to just hang out and listen. All are welcome. You're very welcome, Alina, and I look forward to seeing you tomorrow night as well. And for anyone else who's listening, we do have our Employment Tribunal support group, which is free tomorrow evening for anyone who is going through an employment tribunal process or thinking about it and wants to talk to other people who are doing that, because it can be a lonely journey sometimes, and it's hard for other people, friends and family, to really just understand what it's like. All the specifics of the whole thing. So I've just popped the link in. If you haven't signed up already, you can join that, and I will look forward to seeing you tomorrow evening. Right, so I'm just going to talk through a few more things whilst we see if anybody else wants to join. I'll probably head off in about 10 minutes or something like that. So let's see how we do. Right, I would like to file a formal grievance to my employer about my work colleague verbally abusing me. Oh my goodness, I'm so sorry. Can I attach audio file as evidence supporting my formal grievance? The short version is yes. What you might find, so you can, yes, absolutely. So the way a grievance works, Andre, is do they know that the audio file exists, first of all? They don't have to. It's fine. You can use a covert recording. There's on our website, let me just get the article for you. We talk about covert recordings and kind of things to consider with it. Let's see, I'm going to pop this link in. They do not know. Okay, cool. So that's called a covert recording. What you might want to consider doing, so the way a grievance process works, all grievances in the UK have to follow at a minimum the ACAS Code of Practice for grievances and disciplinaries. Let me just get that link for you as well. Your handbook might have a grievance process as well, and that's absolutely fine, but it cannot overwrite the basic process that you have to have in the ACAS Code of Practice, which I've just linked to here. So the way a grievance works is you submit a formal grievance, which is a letter. It can be an email, can be a PDF, can be a written letter, whatever you want. And then your employer will conduct an investigation. And in that investigation, they will ask you for information about your grievance. And so, for example, what I suggest that you might want to do is that you might want to, in your grievance letter, you can pull out the quotes from what the person has said to you. So, for example, on this date, my colleague said this, on this date, my colleague said that. And then when they do an investigation, they might say, yes, they might say, what I would do is, for now, I would just pull quote dates and times. These are the big issues here. And then the other thing you can do is you can get the full audio transcribed. Now, there are websites that can do that for you, like I think Google even has one. And there are kind of AI transcription things that you can just check over. But then when they ask during the investigation, you can give them a transcription of the audio first. They, if this went to tribunal, you would eventually need to provide the audio file itself, but it's probably, transcriptions are usually easier to work with. And so I would provide just quotes in the grievance letter itself. Then when and say, I have a transcription that is available for the investigation, get them to ask you for the transcription and provide that to them. And then if they still want the audio file, that's absolutely fine. There's nothing wrong with giving it to them. It's not going to be seen as, they might make you feel bad about it, but read that article that I just sent you about covert recordings. You are within your rights to do something like that. And we see a lot of covert recordings getting used in employment tribunal. Right. So, yeah. So Andre, does that answer your question? The other thing is, you're very welcome. The other thing is, if you are writing a grievance and you just want someone to check it over for you, let me just get you the link. We have a grievance template, and we have a thing called a peace of mind check. So if you want, you can use our template. There's other templates out there. But if you do want to use our template, you can pay a little bit extra for a peace of mind check. And one of our coaches will have a look at the grievance letter for you, just to make sure it looks okay, just to make sure it kind of makes sense and stuff. So if you do want that service, it's available. If not, no problem at all, and good luck. Right, so Alina, does my employer refusing transfer and forcing me to either work again with the harassing managers or leave forever count as disingenuous behavior? They also ignored the ACAS code. Yeah, I was wondering about this, Alina. So completely ignoring the fact that you have been harassed by someone and forcing you to continue working with that person is discrimination. Well, let me think about what's the exact. I think at minimum, it would add to an injury to feelings argument. So for example, if you said, because I've been put into this situation and I don't have any other option, I have suffered great distress as a result of this. I've been had to sign off. I've had to take this kind of medication, et cetera, because they've left me no other options. They're refusing to deal with the harm that is continuing to happen to me. And if you do, this is for a schedule of loss. If they have ignored the ACAS code of practice, what I would be including in a schedule of loss, what I'm calling it a schedule of loss, is basically how much money you want them to pay you, kind of your opening offer. It's called a schedule of loss. A little bit further down, you can add on there, if you won in tribunal for any of these claims, and the hey Yolanta, and if the tribunal found that they did violate the ACAS code of practice, the tribunal could increase your award by up to 25%. So if you are if you're putting together here's what I want, and you think that they have violated the ACAS code of practice, then add up to 25%. I've seen 10, I've seen 20, sometimes I see 25. Add up to 25%. Typically, the tribunal thinks about it on how egregiously they ignored the ACAS code of practice. But that would be a perfectly legitimate thing to do as well. And that's something else you could talk to one of our coaches about if you want to do the merits assessment. Good to see you, Yolanta. How you doing? And Buddy Lightweight says, I just watched A Good Employer Will Want You to Know About Your Rights and Options video. It's true, they will. They will. There are good employers out there, I promise. Andre's asking, if they ignore the formal grievance completely, is it not a breach of trust already? So Andre, there is a specific legal term called breach of trust and confidence. And that is the legal underpinning of a constructive dismissal claim. So Andre, if you have worked at that company for over 2 years, and if they are making it impossible for you to continue working there because they are ignoring your grievances or because they've not given you any more work or all kinds of other reasons, then that is a breach of trust and confidence. So you will, you could, if you've worked at a company for over 2 years, you could argue that that is a breach of trust and confidence and that you have been constructively dismissed. So I don't know how long you've worked at the company, Andre, but if that is relevant, that's worth looking at as well. Yeah, buddy, this is a great question. So I was a little confused at the part where you said if the employer delays an investigation, they can prevent a tribunal and they can run that out the 3-month limit. I thought the 3 months only started if they sacked you. No, that's not true. Yeah, buddy. So basically the 3 months starts from the point where the bad thing happened. So let's take a harassment case, for example. Say someone was harassed because of their religion, and one employee said to the other some terrible thing relating to their religion, and that was deeply upsetting, etc., to the person. In that case, say that person then raises a grievance and says, I want you to do something about this colleague who harassed me about my religion. The point where the harassment happened is the starting clock, and the 3 months minus 1 day is from the point where the bad thing happened. Now, if another bad thing happens, then in discrimination cases, let's say the same colleague or other colleagues racially or religiously harass this person as well. You can argue to the tribunal that the clock should get, the time window should get extended out a little bit, because you can say basically, well, that was a continuing act of discrimination. But in most cases, so say it was, yes, exactly, the tactic. But in most cases, it's the bad thing happens, you've got 3 months minus 1 day. Say you wait a week after the bad thing happens and you'll open a grievance up at that point, and your employer drags their feet and they don't do anything for 3 months. That's your clock gone. If they sack you, you might have another claim. You might have an unfair dismissal claim, but that again, and you might have a 3 months after that. But if you had multiple claims, some of them might be out of time and some of them might be in time, which is why employers typically take a really long time when it comes to grievances, because they're running out the clock. So yeah. So Andre's saying they should supposed to answer your formal grievance within 28 days. I'm not aware of there being a formal guidance from ACAS, but your employee handbook might say we commit to answering within 28 days, or a certain company or a certain industry might commit to that. But ACAS's code of practice, I'm not aware of it actually setting a number of days limit, which is super annoying because a lot of people get the clock kind of dragged out on them, and they're waiting and waiting forever. So the key thing there is if you are coming up against your 3 months minus 1 day deadline, even if the grievance process is not finished, still, if you want to maintain your legal leverage, still then go on to ACAS early conciliation, because it's better to go earlier than to go later. And they might fuss and they might say, oh, you never got your outcome, why are you escalating this? And it's like, well, I needed to make sure that I still had the option to go to tribunal if I needed to. It's a perfectly legitimate thing, and don't let anyone make you feel bad about it. You're very welcome, buddy. Right. It's so good to see all of you. This is my first YouTube only live, and I'm really enjoying. Usually I'm on TikTok live, and I'm enjoying the chilled out question vibes. It's a really lovely pace. So ACAS early conciliation delays the clock by 1 month. So yeah, let me just talk through how the clock works. So bad thing happens, 3 months minus 1 day to start ACAS early conciliation. The moment you submit the website form for ACAS early conciliation and you get a confirmation, the clock pauses. As long as the ACAS early conciliation process is running, the clock is paused. Now, that process might run for 6 weeks because you and your employer are actively negotiating through ACAS and trying to resolve the issue. Or it might be, finishes early because one or both of you says, I don't want to do this. It's optional, but you do have to start the process and then say, I don't want to do it. As soon as ACAS gives you a certificate number, then the clock starts again. And typically you have at least a month, and I recommend that people just stick to the month after you get the certificate number to actually make your tribunal claim. So the clock starts again and you have a month to make your tribunal claim. And when I say make your tribunal claim, I mean you submit the ET1 form. And if people do need help submitting that ET1 form, we have an entire guided template that helps people work through their claims. And also we'll check that over for you afterwards. ACAS told me 1 month only. It depends on when you started the pause. And so I typically just tell people 1 month because it can get complex and you don't want any question done about it. Okay, Linda, I'm so sorry. I forgot to come back to you. So Linda's preliminary hearing is a substantive preliminary hearing. I think you're still here, Linda. If you are, let me know. So a substantive preliminary hearing to determine whether or not you have a disability, what they're going to ask you to produce, if you haven't done it already, is probably a disability impact statement. Has that come up, Linda? Or have you been advised about that and advised about what to prepare? And whilst you're answering that, I'm just going to get together a page for you. Substantive, right. Okay, great. So we do have a specific package for people who are preparing for a substantive preliminary hearing. I think they're going to be asking you for a disability impact statement. That's typically what the tribunal asks for, as well as bringing proof of your disability. Right. If you do want some help about what to expect from that substantive preliminary hearing, and want some help getting everything together, check out the link that I just put in there. Our coaches have helped a lot of people get ready for proving that they have a disability, which is what almost all disability claims, the employer objects to the fact that the employer makes you prove that you have a disability, even though in most cases they damn well know that you do. But it's a tactic. It's a tactic to try and delay the whole process, make you drop out, rattle you, the whole thing. And so the coaches can help you get your statements together so that you can kind of move through that and get on with the rest of your claim. Okay, so hi Shaw, good to see you here. Shaw has done a constructive dismissal. Breach of contract to do with keeping bonuses and failing to make reasonable adjustments, and also age discrimination. Whew. Sounds like quite a difficult situation, Shaw. I'm so sorry to hear that. Did you just submit your ET1 claim? Is that what you just did, Shaw? Cool. That's great, Linda. Great job. And I think you're coming to the tribunal support group tomorrow night. Please do if you can, because hopefully that'll be helpful for other people. Other people can talk about their disability impact statements as well. And I know other people have gone through that substantive preliminary hearing that you're going to be going through to prove that you have a disability. Yeah, so Shaw, did you just submit your claim form? Is that the last thing that you did? Okay. I don't know what PHI is. But if you do need some help, that's what we're here for. So I have loads of videos on YouTube that kind of talk through what a great claim can look like, the common mistakes that people make when they do write a claim. So please feel free to check those out. If you do have questions, or if any of you have questions, I'm going to be going pretty soon. So if there is an unanswered question, you can email us. It's hello@vala.uk. And I've just put that email address in the chat as well. But yes, I think I will go just now because I've got a meeting in 20 minutes. So a pleasure to see all of you here today. Thank you so much for joining me. I will be back and live with you soon again. And in the meantime, if you are at the earlier stage, why don't you have a donation button on your YouTube channel? Oh, thank you, Andre. I didn't even know that you could do one. Yeah, most of the stuff is I'm just pointing people to our website. So if there's some support that you would like, you can purchase it there. So, but thank you. I appreciate you. That's, yeah, now I do know. Good. I'm glad you're coming tomorrow night, Linda. Thank you all for coming today. I will see you again soon. And any other questions, have Vala's email address. Alina is saying your support is priceless. I was quoted around £900 for just a grievance appeal. My goodness. That's so expensive. Who can afford these things? This is the thing. Like, who can afford these things? See you all soon. Thank you so much and have a wonderful day. Bye-bye.